what you saw there is what normally comes up when you click. No, me neither. Okay. But I guess next time, if I see that, just re-log into Zoom under the account that set up the Zoom conversation, and there we go. Look at that, you're on network TV. Wait. All right. Thank you, sir. All right, Ms. Rolak, we're live on YouTube now. A little late.
Thank you, Judge.
You bet. We solved the problem. I think next time we'll be able to get it to work. I think they haven't worked the case out yet. I'm going to pretend that it just is louder than it really is because it's an echo chamber.
The issue yesterday with the sound was there was not an audio cable.
Look at that, the two today.
Right.
So someone just invested to, or is that your own? You
No,
just
no, no, I asked
self-
Zilly when she came in, I said, can we run the audio cable? She goes, sure. She goes, but it hasn't been working. I said, it worked the day before yesterday.
Great.
You know, that it does work.
I don't know why it wouldn't work. I mean, it's a static wire.
Future, if it's missing, I'll just pull it out of the door.
You've got something that does the same. Is it that one? I guess you have some long cords that you get stuff. Is this your laptop?
It is, that's for real time.
Just want to make sure you knew it was here if you were.
Yes, sir.
They're negotiating the case over there in the negotiating room. We'll give him a couple more minutes and then we'll go. No issues taking the guy into custody? They seem to go quiet. He was sentenced, so I have his case number, let me look it up, but he's turning himself in because he pled guilty and was sentenced. Okay. Would it help if I printed out the final disposition?
Yes.
Okay, let me do that in just a second. Yeah, he had pled guilty and was sentenced and was
Oh, yeah.
forced to turn himself in.
Yes, that's what we need, that's all, Judge. the final.
Okay, final dispo, all
All
right.
right, let's go ahead. Yeah. Yeah, go ahead, Sergeant. Go on. Look. Yeah, yeah. You know, that's what I was- Get this without everything, yeah, go ahead. Don't worry about this.
You getting beat up back there, do you need support? 2-on-1.
A little bit.
All right, yes, but then we'll get going.
Okay, thank you.
Sure. So this is the, I don't have a stapler.
That's fine.
I've got one, but this is the final dispo for.
Okay.
Signed just a couple days ago. So it's a growth.
Okay. Thank you. Oh.
So do we have a plan?
Well, no, Your Honor, actually have a problem. So, the last time we were in court, when I handed out discovery, apparently all the discovery that was on my USB that I received from the officer did not transfer over when my legal assistant copied it to give to the defense attorney. They both had different things on their USBs, with the evidence they received from my office. I have everything though, so I'm not sure what happened in translation or in transferring it over to the USB, but Mr. Henderson, Henderson doesn't have, a lot of evidence apparently that should have been served on him when I served it, the last time we were here. So, at this time, we don't really have a negotiated plea because he hasn't seen all of the evidence. So his client is not willing to take, which I understand, anything today. Ms. Patel's client, he is taking the offer. However, now that we have an issue with the public, and I was trying to reach out to my supervisor to see how she advised me to move forward. Because it was our understanding that this was a package deal, at least that's what we thought. And now that I'm presented with one saying yes, one saying no, I wanted that advice from her. I think she's in court right now. So, the problem is now that I need to, if you allow, Your Honor, to provide this missing discovery actually to both attorneys, even though Ms. Patel's client will be taking a plea. I still need to give her what she hasn't seen that, co-counsel had already seen or has. And then also, if Ms. Patel client wants to take the plea today, that's fine. We're gonna leave open the restitution amount because that is a little issue right now. But I was gonna ask as a state for a reset, we would leave the offer open for her client so that I can have time to talk to my supervisor to figure how I move forward or to try to move forward with this case after I provided the remaining missing discovery to both defense counsel.
Hendrickson, tell me what was missing from discovery.
At least what I know I don't have, and there may be, and I don't want to disparage any, and the officer in the report says some things that would lead me to, as an attorney, tell my client, hey, this is a no-brainer. We need to resolve this case today. But then when I reviewed what I did get, I will say, I believe the officer took some liberties at best with the evidence.
Okay.
And so I have some doubts as to whether I will even ever get everything. And what I know I don't have is, I have no phone records that the officer, in the video, he slaps down some phone records and says, we can prove you were here, you were here, you were here. I don't have any of that documentation.
Do you have reason to believe that they exist as opposed to that's a ruse that officers can use in interviews? Like we can see on the eyelids of the deceased, the last thing he saw was you holding a gun.
Absolutely. And I guess the answer would be truthfully, I don't know, other than the officer says in his report or in the video that phone records can prove that my client was in the vicinity of these events. Now, I know the officer did lie about, as a ruse, saying that they could prove my client and Mr. Pell's client were in the GSU parking lot, because we all know that wasn't the case because the victim later says that was a lie. But so I know they don't have that information, but
well, at the time, we don't need to go back and forth on it, but if they were relying on the victim being truthful, then they may have felt we could prove you were in the parking lot because the victim said you were. But either way,
right, yeah.
I'll be more specific. What is it that you think Ms. Hall has that you don't have?
So the phone records, I know that, well, I don't know, but I saw on the video, there was one of the videos was a photo lineup that was done. They seem to intimate that there was a photo lineup done of my client, but I don't have that and didn't see that on any of the videos. There was definitely a photo lineup done of the co-defendant, Mr. Willibus. I don't have any of the pictures that were ever shown by the witnesses in the case. I do not have the 911 call that was apparently made, well, had to have been made by Miss Wynn, where she gave, that would have been obviously another false story. There is apparently, I found out this morning, a recording perhaps of my client that Ms. Patel has seen that I have not seen, where I don't think it's going to be that valuable. It's just where he basically says he doesn't want to talk to the police. But and then there is Mr. Willibus's phone records that they, again, I don't know if those exist or not, but they said on tape that they do. There was a lot of talk. I know that in the last video that I don't know if Ms. Patel has seen it. They did a search warrant of Mr. Willibus's phone, and apparently found a bunch of information, or I don't know what they found, but I haven't seen any of that. There were 3 written statements, according to the reports done by the alleged victim in the case. I don't have any of those. So that's, at least briefly, that's what I know that I don't have.
And how long have you known that you don't have these things?
These are the things I talked about last time we were here. And then when I went through the flash drive, I finally got through the last part of the flash drive video last night that was sent to me in the mail because there was problems recording, and it's a 3.5 hour interview, so I watched it over.
Interview of Mr. Willibus?
Yes, sir.
Okay. But you have never had your clients interviewed?
I don't know that it's much of an interview, so I'm not.
But you've never had it?
But I've never had it. I do have a video where they go to his house and they do well, first I thought it was a search warrant. I think it was actually a consent search, but they did search his house. And I saw a bunch of body camera footage. There was a lot of videos of that, but I don't have a separate interview where, as I understand it, he was in the police station.
And how long have you known that Ms. Wen made different written statements, but you don't have them?
The written statements I've never had. That was something we talked about the last time I was here, that we didn't have those written statements.
Okay.
I assumed I was going to get those on this last flash drive, and I think they tried to, it sounds like Ms. Hall tried to copy those, but it just didn't happen.
When did you let Ms. Hall know that you didn't have the things you thought you were going to get?
I let her know that this morning. Up until...
Why not before this morning? This morning is when we're supposed to work the case out, if it's going to work out, not to say, this thumb drive you got me, however long ago you got it, didn't have what you said would be on it.
And that's a fair point, Your Honor, and I apologize. The only thing I can tell you there is up until I met again with my client 2 days ago, And then I gave him until this morning to give me a final answer as to what he wanted to do, because he was on the fence. And quite honestly, I felt like we were probably going to be able to resolve this morning. The state, I think, has made a very fair resolution. But I also understand my client's hesitancy to sort of take this, knowing that there's a lot of stuff that his attorney doesn't know. And so I understand his decision.
Okay. Ms. Patel, what do you still not have? That you know you don't have?
So this morning I learned that there are 2 recorded statements with Tina Wen that I don't have. Those would have been the initial first 2 interviews. And let me just preface, I brought this to Ms. Hall's attention today because in speaking with Mr. Hendrickson, that's when I started to piece together what all I was missing. And I didn't know Ms. Hall had everything. I thought Ms. Hall gave us only what she had because she was having so much difficulty with the lead detective in getting the file.
Do you now understand that Ms. Hall has Ms. Wen's recorded statements?
I know that because Mr. Henriksen does, so
Okay.
I do believe that Ms. Hall has them.
Got it.
I believe she did say that she has the phone records of Mr. Willis's phone dump.
The line. The phone, but I don't think it would happen. I think that was
So they do actually execute a search warrant on.
Oh, yeah.
Right.
Yeah, I thought you were talking about the papers.
No.
All right, stop. We'll work through this. So you don't have Ms. Wen's statements, but we know they exist because the state has given them to
Right, so I'm missing
Perfect.
2 recorded statements, all 3 written statements. I'm
Okay.
missing both lineups. Mr. Henriksen and I are both missing police reports that existed after the first police report. So the first police report assumed everything that she said was true, but there are later police reports in which they update the case. So all the supplemental reports we're missing. We're also missing the information in regards to her case. So any exculpatory investigation for our clients that they, in investigating her false statements. There was, Ms. Hall indicated that she doesn't think that dash camera exists, but the complaining witness had dash camera in her car that the officers say that they review. It could have been a ruse, but that I learned that in watching the statements that, so I don't know if that exists or not.
So Ms. Wen had her own personal dash cam, according to the officers.
According to Ms. Wynn, yeah.
Right, okay.
And yeah, she was supposed to bring it in. I don't know if she ever brought it in. If the police
Okay.
ever got it.
And when I talked to the officers, Your Honor, that did exist, but the contents weren't pulled off of them, so now it doesn't exist. So
Okay,
there was something that existed when this incident happened, but because they didn't request or get that stuff pulled off of that video, that's something that the state doesn't have.
anything else?
And then any photographs. So I don't know if they took photographs of her. I know that they took photographs of my client because that's in the video. And they should have taken photographs of the inside of the car. We don't have those, and the only reason I say they should have is because she said that a gun went off inside the vehicle.
Her car,
Her car, correct.
along with the dash cam.
Right.
Okay,
But with that being said, we were ready to move forward today because of what the state provided us through discovery that we are ready to accept the state's offer today and move forward on our end.
okay. That's what we're gonna do. It's final plea day, and the state needs to share what its offer is, and if Mr. Willis wants to do that, he can do that. Mr. Massacre wants to let this offer expire, he's free to let it expire. Both sides have had so much time to get discovery, flag the discovery is missing, and not bring things up at the first, second, third, or fourth time that we've got everyone together. So If the state wants to leave the offer open for Mr. Mazaku, the state's free to do that, and he, after he gets this additional information, can decide to take that offer if it's left open. But we're going to go forward today with the final plea hearing for both gentlemen, and we'll get where we get with that. It does sound like there's more material that both defendants are entitled to. None of it strikes me as material that is going to fundamentally reset the attorney's perception of what this case is about. If I'm wrong about that, then I'll reconsider what I just said. But in particular, the fact that Mr. Willibus, even though some of these things his lawyer doesn't have, is ready to go forward, it tells me that there's not something out there that's going to say Mr. Mazaku was in France when he wasn't even in Georgia when it happened. So that we're sort of at the edges of, was it as bad or not as bad? And I want to be clear, I get it that the basic storyline now is that Ms. Wen made a whole lot of stuff up. But the case is not going away. The state doesn't have to dismiss it. We can take it to a jury. I'm getting the sense that they are greatly reducing things. And it's to a point where Mr. Willibus is ready to go forward. I want to honor that. Mr. Mazaku is not. I'll honor that as well. And certainly, Mr. Hendrickson and Mr. Mazaku are entitled to get the missing pieces before this case would have to be tried. But I'm done letting the two sides go back and forth. Like, well, I don't think I have this, and where's that? I'm not faulting the defense attorneys, to be clear. It's not your job to produce the discovery. I'm not faulting Ms. Hall to a certain extent, because I'm recalling that there was a whole lot of trouble getting info because this one detective has gone on FMLA. These are complicated times. I am faulting the state for not figuring out how to get both attorneys the same thing. That is no one's fault but the state. Who it was doesn't matter. It didn't happen. But before today, people should have said, wait a minute, what did you get? I don't have that. Hey, I need this. Mr. Hendrickson, you helped me understand why you were throttling back a little bit, because it seemed very resolvable. Your client's entitled to say it's not so resolvable right now, but that just means he and Mr. Willibus are going to go for a little while on separate paths. And he, Mr. Mazaku, and you, Mr. Hendrickson, may want to keep chatting while Mr. Willibus enters his plea. But that's what we're going to do right now, assuming Ms. Patel, Mr. Willibus still wants to go forward.
Yeah, I do just need 5 minutes as a first offender plea, so I just want to go over all of the conditions behind that before we take it.
Okay, great. I'll be right here.
You know, and I will step out and speak with my client, Your Honor, and
Great.
I will hang out and I'll observe, I suppose.
Sounds good.
Thank you, Judge.
Your Honor, are we doing the plea sheets?
Ideally, we haven't, because everyone's not all in the same place. If you have concerns such that it ought to be doubly memorialized, we can do that. If you don't have concerns, given that requires you all to be closer together for a longer time, I'm fine waiving that for now.
Thank you.
Judge, would you like me to send you that indictment?
Yes, please. Thank you.
Mhm.
Sir, are you here for a case or are you just observing? Okay. You're welcome to be here as long as you want.
Just don't even have enough judge, President?
That's it. We'll see what happens.
Oh. You see? I heard you, but I've seen you.
How far away do you live from the courthouse?
8 minutes.
Ah, that's close. My gosh.
Well, she big time, big one.
No.
Yeah,
8 minutes, that means in the city.
it is. It means one of those fancy loft condos or something.
Yeah, it's right down P Street, on P Street.
On Peach Street.
I know, I'm from there, like, Fulton County is my, my something firm.
Uh-huh.
This whole little area.
You went to school in Florida, you went to school in Florida?
University of Florida.
You were there.
There's, oh, well. She's nice otherwise.
You know, I went to law school in Alabama, so, you know.
Oh.
I got the best of the football. I didn't know I was gonna be home and never services. That was my plan for that.
We were flying along,
We were,
but this case is snake bit.
got you out yesterday when I talked to the victim.
Ms. Wen, who's a defendant, and she's treating you poorly?
Not her, I talked to the attorney. He didn't like the offer we're giving. to the-
Who's Ms. Wen's lawyer?
Mr. Michael Dixon.
Is that a private attorney? He doesn't have a good basis to be fussing.
Right.
She's have a record. They kill me with that.
We can't hear you, Jeremiah.
Oh, even though they have a record, they kill me with like that when people have records and.
Oh, no, none of these guys, none of these people have records. It's just
Oh.
circumstances of what happened. I think this is one of the most difficult things as a prosecutor.
Really?
Because I look at it like, things could be true that were stated, and then when you lie, you make it hard for us to figure out what really happened, and so.
Yeah.
I don't know.
Don't know what to trust.
And it's hard because it's a serious case, you know. I feel bad if anything happens. Yes, Ms. Judge, you know, I've been in non-context my whole career.
So you've been here for a while now, it's not a
Yeah.
whole career.
I guess I forgot you've been here for a minute now.
Yeah.
Stuck in this 10 minutes.
I'll get you a trial someday. So you'll need to jump on with major case, because the first ones to go will be those.
No, I'll be right there. I thought it would be the time I'll be able to relax, and I said, no, she's gonna make me second shift, which is fine. 'Cause I need to learn. Oh, wow.
Ms. Patel, are you ready?
Yes, Your Honor.
Great. We're all present. We'll keep the Zoom feed going because Ms. Nelson and Ms. Crawford need to be able to hear what's going on. But you should feel free to position yourself where you're most comfortable, and same with Mr. Willis. But Mr. Willis, you should come on up because you're going to need to get some things on the record with the court reporter. So pick one of those seats there or come to the podium. Like old times, where do you want to stand? That's probably a great spot. Okay. Is everyone ready? Okay. We'll go on the record with position 11 on our final plea calendar, State versus Christopher Willibus. It's 20 SC 174728. Good morning, Mr. Willibus. How are you doing today? You stay up late last night or you work late last night?
I'm very good with sleep all night, even when I go to sleep, so I was like,
How old is your baby brother?
he just was 3 years old, he's 4 years old.
Okay, and why was he having trouble sleeping?
He used to be a night owl with me, because I used to work with kids, so.
Oh, so he'd stay up to see his big brother.
Yes,
Got it. All right, get him on a normal schedule.
I'm sure.
Are you not working at UPS? They're hiring a zillion people now. Two men in a truck?
Yes, sir.
Okay, great. My understanding is that you are interested in entering a first offender plea to some set of the charges here. I suspect some of them are being dismissed if you're going forward. Is that correct?
Yes, sir.
In a moment, Ms. Hall's going to put you under oath. Once you're under oath, it's important that you answer her questions and mine truthfully. If you have any questions of your own, let Ms. Patel or me know, and we will make sure we answer them. Will you let me know if something comes up? Great. Ms. Hall?
Thank you. Mr. Willis, can you please raise your right hand? Do you swear or affirm the testimony you should give in the matter currently before this court should be the truth, the whole truth, and nothing but the truth? You may lower your hand. Your Honor, for the record, the state is notifying count 1, which is armed robbery, count 2, which is aggravated assault with a deadly weapon, count 3, which is aggravated assault, count 5, which is possession of a firearm during the commission of a felony, and the state is amending count 4 from criminal damage to property in the first degree to theft by taking a felony.
Okay, that's quite a change. So, Mr. Willibus, I need to make sure you understand your plea that you're entering, which may be a first offender plea, if I accept that, is to theft by taking. The allegation is, and I'll learn more about it, you took something that wasn't yours without authority to take it. No guns, no armed robbery, nothing like that. Do you understand that? Is that what you expect is going to happen? Okay. Thank you, Ms. Hall.
You're welcome. Mr. Willis, can you please state your true, correct, and legal name?
Christopher Nelson, Anthony Moves.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine? Is there any medication that you normally take that you have not been given today?
Can you spell your first middle name?
Ms. Willis, how old are you and how far have you gone to school?
22 years old now, graduated from high school.
Are you able to read, write, and understand the English language?
Yes, sir.
Do you understand that you've been charged with criminal damage to property in the first degree being amended by the state to theft by taking?
Yes, sir.
Do you understand that you have the right to plead either guilty or not guilty to that charge? And if you plead not guilty or remain silent, you may receive a jury trial. Have you had enough time to speak with your attorney, Ms. Patel, about all the facts and circumstances known to you regarding the charge in this indictment, including any potential defenses?
Yes, sir.
Do you need more time to discuss this case with your attorney?
No.
Are you satisfied with her services?
Yes, sir.
Counsel, do you waive formal reading of the indictment?
So wait,
Do you waive any and all defects in the indictment, including with respect to the defendant's name?
wait for the purposes of this plea only.
And do you waive moving forward on the copy of the indictment?
We wait.
Mr. Willis, have you been arrested on this charge?
No.
That I asked because the state is unaware of any outstanding warrants that are related to these charges. Do you or your attorney know of any outstanding warrants related to these charges? Has your attorney advised you of the minimum and maximum sentence for the charges you're pleading to?
Yes, sir.
The minimum maximum sentence for theft by taking is 1 to 5 years served. Do you understand this is a negotiated plea of guilty, which means the state will recommend to the court a sentence of 3 years probation plus restitution amount of $1,500 to be paid to the victim, but the court does not have to accept. But you'll be joining salary liable for that, so you'll be responsible for half of the 1,500. The total amount of restitution is 1,500 though, so if your co-defendant does not pay that, you will be responsible for paying the whole amount. But the court does not have to accept that recommendation. The court can sentence you to the maximum on that charge, which is the 5 years to serve. Do you understand? Do you understand this plea may be used to enhance sentencing on other convictions in this jurisdiction as well as other jurisdictions, including the federal courts? Do you understand if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence? Do you understand you're not allowed to possess or use a firearm while on probation? Do you understand if you're not a United States citizen, a guilty plea conviction will affect your immigration status and will result in deportation, just as a conviction at trial would? And this is true regardless of any advice by your attorney or anyone else. Do you understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm, or use a firearm in crime, you will be guilty of a felony which may carry a sentence of 1 to 15 years in prison? Are you asking to be treated as a first offender under the provisions of the First Offender Act? Have you ever pleaded guilty or no longer contended to, or ever been convicted of a felony in the state of Georgia or any other jurisdiction? Have you ever been sentenced for any crime, felony or misdemeanor under the First Offender Act? Has your lawyer explained the First Offender Act to you? Do you understand if you violate the terms of the first offender sentence or commit a new offense while on first offender probation, your first offender status could be revoked, you could be adjudicated guilty, and you could be resentenced up to the maximum sentence for this charge in this indictment? Do you understand that you waive any amount of offenses, including any mental health offenses, by entering a plea of guilty? Do you understand that if you went to trial, you will have the right to a trial by jury, the right to speak, hear, and confront witnesses called to testify against you, and the right to remain silent and not incriminate yourself? Do you understand that by pleading guilty, you're giving up the following rights: the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses against you, the right to the assistance of counsel hired by you or support appointed counsel, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt, and the right to appeal if convicted of these charges after a trial. Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea? Is it your decision to waive these rights and enter a guilty plea because you're in fact guilty? How do you plead to the one count of theft by taking felony in indictment number 20 SC 174728? Is this guilty plea freely and voluntarily given with full knowledge of the charge against you? Do you understand that you only have a limited right to appeal this guilty plea conviction? Do you understand that you only have 4 years from today for a felony charge to file a habeas corpus petition challenging the voluntariness of this guilty plea? Thank you. Your Honor, the state is unaware of any felony convictions by this defendant and had this case proceeded to trial. The state was proven that on September 27th, 2019, at or around 521 Capitol Avenue, Atlanta, Georgia, in Fulton County. Officers were dispatched to property in reference to an armed robbery. While investigating that armed robbery, they learned from the victim that 2 individuals entered her car, demanded her property. Ultimately, a shot was fired inside of that vehicle, and the defendant, along with his co-defendant, took the victim's book bag out of her vehicle. What we have learned through investigation is that the victim lied about a lot of things that happened in this case. She lied about the location of this incident. It didn't happen on Georgia State property or in Georgia State jurisdiction. It actually happened in Little Five Points, which is APD. That's still in the county, in Fulton County. And she also lied about the incident that led up to this alleged armed robbery. She told authorities that she was just sitting in her car and 2 black males just entered her car, when in actuality this was a drug transaction. We sent the state has been negotiating this case, as you know, Your Honor, with um, both defendants and as well as trying to work with the victim in this case. Because this case has now become, a case where we really don't know what happened inside of that vehicle, Your Honor. We do know that there was a gunshot fired. We do know that there was a bag that was taken from that vehicle, but we also know that the victim had a gun and the defendants had a gun as well. The investigators who investigated this case, in their report, they said that they believe that the victim was there to rob the two defendants, but they may have robbed her first. That's their professional, opinion from their investigation after talking to everyone involved. What led to the defendants being caught ultimately was, there was a tracker on Miss Wynn. Miss Wynn is the victim. Her book bag was stolen. Inside of her book bag was a laptop. She remembered days after this incident that her laptop, her MacBook had a tracking device on it. That tracking device led them to co-defendant Mr. Mazacu's brother's house, where the laptop wasn't discovered, but that's where it pinged to. He was taken in. He did not talk to authorities, but he was receiving text messages from Mr. Willoughby's co-defendant. One of the messages that the officers read after getting the search warrant of the phone was Mr. Willoughby telling Mr. Mazacu to keep his mouth closed. They did search that phone to get more evidence. In searching then Mr. Willoughby's phone, they did realize that there was a name of Jack Frost in that phone, who was Miss Wynn. That I'm assuming that is her drug dealing name.
Let me pause you for a second. You are assuming that Jack Frost is Ms. Wen, or you know it's Ms. Wen, and your assumption is when she was conducting that kind of business, she went by Jack Frost.
The letter.
Okay.
So
And I also want to make sure, so law enforcement found Ms. Wen's laptop in Mr. Mazaku or his brother's possession?
well, it wasn't, the tracking led them to the house, but
Okay.
they were never able to find the actual laptop. They talked to many people there. They said, I don't know why that particular laptop would be there. He said he didn't know anything about it, but the tracking.
But of all the houses on planet Earth, it went to Mr. Mazaku's, who then also was receiving texts from Mr. Willoughby saying, let's just be quiet about this.
Yes.
Okay.
So when Mr. Willoughby gets arrested, he was very forthcoming with the investigators. He told them that that's not, the way the incident was reported was not actually what happened. And I'm sure Ms. Patel's gonna tell you everything she observed during that interview, but it was, a lot that happened. And in the midst of everything that was going on, he kept trying to, advise officers to get his phone, to look at his phone to prove that they actually knew each other, and it was.
They meaning Jack Frost
Jack
knew
Frost.
these two gentlemen.
Yes, and that it wasn't an armed robbery, that she pulled the gun out on them, and yes, he did admit to taking the bag, and, ultimately, I think that he did.
That's the theft by taking and hence the restitution.
Right,
Okay.
and that is all from the state, Your Honor.
Quite a case. Thank you.
You're welcome.
Ms. Crawford, I guess you can't see me. Let me turn the video back on. But I am here, I promise. There we go. Any criminal history for Mr. Willoughby?
No criminal history found, Judge.
Thank you. Ms. Patel.
Thank you, Your Honor. Before you is my client. He is a high school graduate who did go to Morehouse. He ended up having to drop out because he got diagnosed with Crohn's disease and was suffering from flare-ups. Currently, he's working full-time with 2 men in a truck. Before he was incarcerated, he'd been working at Subway, so he's done a pretty good job of trying to maintain employment throughout this time. He has a very supportive family. His mother was at his bond hearing. She's come to his other court dates. You
said bond hearing. How long was Mr. Willoughby in custody because of all this? Just ballpark.
5 or 6 months, because the only reason I even found out about everything else was that I looked up her name on Odyssey and found the indicted case for the false statements, because the only thing that we still have to this day is the initial police report that treats this as an armed robbery.
Okay.
And so it was through that that we uncovered everything else in this case. With Your Honor, so this case, as Ms. Hall has indicated, is very, very convoluted. The interesting thing that I would say, and I think that Ms. Hall would not necessarily disagree about, the impact of a detective's bad decision-making on how a case can be uncovered. And in this case, his mind from the very beginning was fairly made up that he was out to find two Black men that were involved in this deal. And so when he came across my client, he was already pretty upset. And it's really difficult to get through the first part of my client's interview because the officer is completely unprofessional.
He is with Georgia State or he is with APD?
Georgia State.
Okay.
And
And remind me what ultimately led law enforcement to your client. I understand Mazaku because the laptop was pinging from an address associated with him. But then,
the text messages that my client was sending Mazaku while he was in custody led them to believe Mr. Willibus was involved.
so Mr. Mazaku was arrested first,
Correct.
and Mazaku is communicating with Willibus, and law enforcement figures that out and says, "Ha, this is the co-defendant,"
Correct. So,
which turns out to be correct in the sense that this was the other person in the car.
correct.
Okay.
So, he pretty much what you can see in both of his interviews with Ms. Wen and Mr. Willibus is just the total different treatment of both of them. And he comes up fairly racist, to say the least. He calls my client a thug, a gangster, calls him inner city. He says he's hood. He says his mother's going to go to jail for this and that he's going to make sure that his family goes to DFACS, or his siblings go into DFACS. He says things like, "You want me to believe that a 5'5" Asian girl would rob you? You're stupid, you're dumb." And this entire time, Mr. Willibus is just saying, "Please look at my phone. You have my phone. I've given you my phone. Just let me show you." And the officer says, "No, I'm going to get a search warrant on your phone. I don't need to look at it. I don't need to look at it." This happens for over an hour that my client is like, "You're not listening to me. Let me explain what is happening." They eventually have to bring in a Black police officer to talk to my client, and that officer actually goes over the phone with him. My client logs into the app, is ready to show him everything. And it's just unfortunate because what we're missing is a lot of things in this case. We have dash camera that may or may not have been viewed by the detective before this.
So since we're on the record now, you believe there's dash camera from Ms. Wen's vehicle. We haven't confirmed that, except that Ms. Hall believes that if it did exist, it has since, I don't know if it's expired, been recorded over, but as I understand it, there is not today a dash camera that we could watch on this large screen in the courtroom to see what happened inside. I think it was a Mercedes that Ms. Wen drove.
Correct. And it might be that law enforcement viewed it because they do make references to parts of what they said that they observed. It's unclear. And my client says, "I can show you in the dash camera exactly like who was who, was the whole time was asking, bring all of that and I'll show you." When they talk to her, this is the third time she comes in with a different story. She's already admitted to lying and they just reassure, "Don't worry, these guys are going to go to prison for a very long time," even after they talk about how much money she wasted in them investigating the wrong location. They even pulled camera footage of another Black man walking by. She could ruin that man's life because they were trying to figure out if he was tied to this.
So what do you think happened inside the car?
So my client says he's adamant he doesn't know which gun went off, and if they had just done the forensics, we would know which gun went off. because we know what gun was hers. And I don't even know if they collected a shell casing or a bullet. We never got to look at photos of whether there was actual physical damage done to the car. But when my client spoke, he said the gun did go off because the guy in the back was struggling with her because
Is the guy in the back someone other than Mr., are there 4 people in there?
So my client is consistent in his 3-hour statements that there are 3 people involved. Mr. Mazaku is driving a black car. My client and another gentleman. That gentleman gets into the back. That's the guy that had the gun. He says that this guy was light-skinned with chin hair. Ms. Wen actually does describe the same thing. She says the guy in the back was light-skinned and he had a chin strap for facial hair.
So Mr. Mazaku was not in the Mercedes.
My client never puts him in the Mercedes, and there's a little bit of confusion because in the police report, the officer just writes, during my interview with Mr. Willowbis, he said Mr. Mazaku was the guy in the back with the gun, but we have now learned after watching this that that statement is never made. You know, he actually says things like, Jeffrey's too dumb to be someone that I could bring into a car. So he over and over says, you know, that it was a light-skinned guy. She says that the guy in the back was also light-skinned. I mean, I think you could look at Mr. Mazaku and it's not light-skinned.
Not light-skinned. So this mystery light-skinned guy with the gun is someone that Mr. Willowbis brought to the scene?
So he picked him up on his way to go to Inman Park. So
Mr. Willowbis did.
Mr. Willowbis picked this. So Mr. Willowbis was hanging out at the Chevron gas station on Moreland, which I think is a different name now. He met him that day, and the guy was like, "Oh, you're picking up pens? Can I get in on that?"
And
Vape pen cartridges.
Okay.
So, and that all goes back to, you know, he was trying to buy 50 pens, which
He,
is
Mr.
my
Willowbis.
client, which is $1,000. So that's a lot of weight that Miss Wen was moving.
so the light-skinned guy was a chance encounter at a Chevron where Mr. Willowbis was hanging out. They joined forces, if you will, to
Right.
buy bulk pens from Jack Frost.
Right. My client was going to buy them regardless. And then I think that we're the
And what does
officers.
Your client say, just so I'm understanding, what does your client say Mr. Mazaku had to do with anything? Did he drive your client there?
That he was the driver of the vehicle that, right, that he drove in there.
So for Mr. Willowbis to get to Ms. Wen to meet up in Little Five Points, he got a ride from Mr. Mazaku, and Chinstrap came along because Mr. Willowbis said, that's fine, you can buy some too.
Right, we'll buy them off of him once he got them.
Oh,
So
so he was Willowbis was gonna play middleman.
kind of like, more like, I'm gonna pick this up, if you want to be a part of it, sure.
Okay.
And so I think that why the officers were starting to believe Ms. Wen was definitely not telling the truth about what happened is the deal was for 50. She says she shows up with 4, and they're like, well, that seems a little strange, especially if you were about to get $1,000. And she kept telling the officers, oh, well, I just wanted to meet him first, and I wanted to see what he was like.
Okay.
And
But in the
so,
end, when Mr. Willowbis gets out of the Mercedes, he leaves with her bag.
right, he admits, like, I guess she had a backpack in the back and a purse in the front, and he admits, I took the purse, the other guy took the backpack, and I yelled at him to, like, throw that out of the car once we fled.
And fleeing would mean Mr. Willowbis and unknown man get into the car with Mazaku. This is all according to your client. Mazaku drives them away from Wen's Mercedes.
Right.
Okay. And then you can drive back and say, I'm sorry, we took your stuff, here's your stuff.
No.
Okay.
You know, the officer asks him, you know, why didn't you call the police? And he's like, well, I was buying drugs. I didn't think that would be a good idea.
But the drugs were vape pens.
Correct. So right, the THC vape pens.
Oh, okay.
Right.
So not what you could get at, I don't know where you buy vape things. Do you buy them at a gas station convenience store? but.
Right,
these you
that's
could not.
different, not like a duel. And to be clear, it's unclear whether my client never states Mr. Matthew knew what went on in the car, but they do leave from the location. And again, had my client not given them all of this information, they would have never really figured it out because they were so adamant that this must have happened at Georgia State.
Okay.
With that being said, so what we did want to request from Your Honor, two things. I understand and we understand Mr. Maxico's case hasn't resolved, but if there is a resolution, whether that be trial and a resolution after that or plea, we wanted to see if Your Honor and the state would be willing to allow him to have his cell phone back after everything's done. He did turn it over to law enforcement. He just wants that back at the end of the case.
If the case is closed, then the phone's not contraband. And it's Mr. Willivis's, I guess arguably the state could seek to forfeit it because it was instrumentality of a drug deal. I can't make the state do it, but Ms. Hall can give us her best sense of what might happen with the cell phone.
And then the other thing that we want to ask Your Honor is, given the restitution in this case, if my client, I've seen this done before, if my client is able to maintain a full-time job and prove that to probation, if Your Honor would waive those fees while he maintains the job so that he can make payments towards restitution.
Waive the supervision fees.
Correct.
Okay.
But that is all that we have to say about this situation.
It is indeed a complicated case. Ms. Hall?
I just wanted to add, the last thing that we talked about this morning, since, Mr. Matthew is not going forward, we did talk about, Mr. Willis. Oh, I'm sorry. Yeah, that's take all of it.
Okay. It's withdrawn. Mr. Willis, where'd you go to high school?
I went to Twins Academy, private school.
Say that again?
Speaking of my academy, private school, it was a homeschooling academy.
Okay, what was the first word?
Twins Academy.
Twins,
Yes, sir.
like Minnesota Twins.
Yes, sir.
Queens Academy. Okay. Okay. Did you have hair like you have now back in September of 2019 when this happened?
Yes, sir.
So you have distinctive hair.
Yes, sir.
They were actually dreads, not,
Yeah, they were.
they were dreadlocks.
Okay, were they that color?
They were a form of gray. They weren't this gray.
Okay, your hair's wonderful. I'm just asking as I try to process how the police investigated this case. Okay. Mr. Willis, the first thing I want to say, it's not really my role to do so, but I'm part of the criminal justice system. I apologize for the way in which your interrogation went. There's a time and a place for officers to be hard-nosed about things. This doesn't seem like that kind of case. It also seems like you were treated at times in ways that weren't professional. Officers can use ruses. They do it all the time. Oh, your buddy already confessed. Oh, I better tell you what happened. I don't have an issue with that. But starting to call you names and treating you other than an accused, that's not the way it's supposed to work. And insofar as that has tainted your view of law enforcement, I'm sorry about that. They're not all that way, but the way you were treated seems like it was unprofessional and not something you should have gone through. Even if that detective believed in his heart of hearts that you were a dangerous arm robber. So take it for what it's worth, but I'm sorry that it played out that way. That's nothing the DA had anything to do with, and obviously nothing the court did, but it shouldn't have played out that way. Even if they want to be hard-nosed about things, there are professional ways to do it. Second, I need to talk to you about first offender. You are asking to be sentenced as a first offender. You certainly qualify for it. The benefit of first offender is that if I accept your plea, it's not a conviction. And it will remain not a conviction as long as you do okay on probation. And if you successfully complete your sentence, then it never was a conviction. So if you're looking for work go back to Morehouse, whatever it is you want to do, you don't have to check that dread box. Do you have a felony conviction? If I accept your plea and sentence you today, when you leave, it's not a conviction. You're a first offender. That's the big benefit, because this all goes away. Not your memories of it, but all the paperwork associated with it goes away if you successfully complete your sentence. The risk that I need to make sure you understand is that if it doesn't go well for you on probation and you pick up new charges, let's say you're still out there wanting to wheel and deal in THC pens and you get caught. Not only do you have those new charges you have to deal with, but you'll come back here and there's the possibility that I could take away your first offender status and resentence you from scratch. Not on all the dismissed charges, so you don't need to worry about the armed robbery, but up to 5 years you could be sentenced for this theft by taking. Now, if you know that probation is not going to be an issue for you, then this is a great opportunity. But I need to make sure you understand the downside, the potential downside to being treated as a first offender. Do you feel like you understand it? Understanding that, do you still want to be sentenced as a first offender? Okay. I'm going to accept your plea. I find there's a factual basis that you and this mystery person in the backseat of the car took the property of Ms. Wen that didn't belong to you. She did not ask you to take it. And in the larger scheme, you should not have taken it. Maybe at the moment, it seemed like the safest way out of the car, who knows? But it was something that shouldn't have happened. And it sounds like there were steps taken later where you tried to conceal the fact that you had taken her stuff and lay low, etc. So there is a factual basis to that little piece of all the many charges that were brought against you. And that's the only one you're pleading to. I also find that your plea is knowing and voluntary. Knowing means that you've understood all the many things we've talked about. Is that correct? Voluntary means that no one's forced you to enter this plea. While you may be frustrated that you find yourself in this situation, it's your decision and yours alone, upon advice of your lawyer, to go forward with this plea. Is that true? Then I'll accept your plea. I will sentence you as a first offender. I am sentencing you pursuant to what we call the Probation Options Management Act. And all that means is that if you have technical problems while you're on probation, maybe you fall behind in making payments or something like that, you and probation will work that out. You don't have to come back and see me. But if you catch new charges, we will get back together again and talk about what to do with this case. I will sentence you as to count 4, which has been changed to theft by taking, which we'll pretend is a lesser included of criminal damage to property in the first degree, to 3 years probation. Special condition of that probation is that you are jointly and severally liable in the amount of $1,500 restitution payable to Ms. Wen. You do not give that to her directly. You'll give it to probation. They'll give it to Ms. Wen. Your probation can become non-reporting after you've paid the restitution. And I will waive your probation supervision fees as long as you can document to probation that you're working at least 30 hours a week. If you're working less than 30 hours a week, you are going to have that additional fee to pay. If you're working 30 hours or more, as long as you're still paying the restitution, you don't need to worry about your supervision. And once you pay the restitution, you're not going to be supervised anymore. It can become non-reporting. Ms. Hall, anything else? Maybe no contact with Ms. Wen?
Yes, Your Honor.
All right. The other condition is, and I suspect you want this as well, no contact with Ms. Wen. Don't buy any more pens from her. Don't call her. Don't write her. No Jack Frost. And don't have any of your friends do it on your behalf, whether it's to say sorry or I'm going to get you next time I see you. You and Ms. Wayne go separate ways. Does that make sense? Any questions about that? Ms. Patel, anything else on behalf of Mr. Willis?
No, Your Honor.
Thank you for doing your best to get to the bottom of the situation. Mr. Willibus, we need to get a little bit of contact information from you. Ms. Crawford, who you'll see on the screen in a minute, is with probation, and she's going to need to get an address and give you reporting instructions so you know when to show up and where. All right? When you're ready, Ms. Crawford.
Hello, Mr. Wynn. I'm Mr. Willoughby. I'm Miss Crawford from probation. I need to get an address from you.
3703 Radcliffe Boulevard, RAD.
I can't hear him.
It's Radcliffe, as in Daniel Radcliffe,
Excuse me.
as in like Daniel, the Harry Potter.
Not familiar with it.
Okay.
RADCLIFFE
Yeah.
Boulevard.
So it's R-A, D as in Delta, C as in Charlie, L-I-F-F-E, Radcliffe Boulevard.
What's the numerics for that street?
3703.
3703?
Is that an apartment? What city?
It's a home in Decatur, Georgia.
Decatur, home? What's the zip?
30034.
30034.
A telephone number?
404-599-5739.
Did you hear that?
Yes, 404-599-5739.
Yes, ma'am.
Okay, and then I need a contact person's name and their telephone number.
Onika Bullis, OEKA, same last time I know this, and 404-621-3052.
I didn't catch it, Judge. I caught the last name was Willoughby, didn't catch the first name or the telephone number.
Sorry, we had some folks coming through court. What's the first name? How do you spell
OEKA.
it? O-N-E-K-A.
And cell number is 404-621-3052.
Did you get that?
No, Judge.
404-621-3052.
Okay, and do you reside in Fulton County?
Say, DeKalb County.
DeKalb. That just means your probation is going to be supervised out of DeKalb. You don't have to move, it's just, it'll be staffed differently.
Gotcha. Sounds good.
So I'm going to give you a reporting date. The date will be October 6th of this year, October 6th, 2020. I'll give you a reporting time of 8 a.m. And let me give you the address for DeKalb County. Okay, your address is 2910 Miller Road. That's Suite 150. And I have a telephone number if you need to write it down.
I'm ready.
Okay, the telephone number is 678-856-6134. And again, the date is October 6th at 8 a.m.
Ms. Crawford, can I have the first digits of the address again?
The address is 2910-2910 Miller Road, Suite 150.
Thank you.
You're welcome. And that's it for me if you don't have any questions.
I think we're good. Thank you, Mr. Willoughby. I'll sign the paperwork later today. You've got your reporting instructions between now and then. Just keep working with 2 men in a truck and help your little brother get on a normal sleep schedule.
Yes, sir.
All right? Thank you. So let's turn to Mr. Mazaku, so we don't leave that piece hanging. Was the offer the same for Mr. Mazaku?
Yes, sir.
Okay, and are you willing to leave that offer open while you and Mr. Henriksen work on getting him whatever additional information you have?
I didn't plan on it, but I forgot that we didn't make that mistake, so we will.
Okay. Yes, you'll leave it open?
Okay.
All right, so Mr. Henriksen, the state's gonna leave that offer open. How much time do you want to work with Ms. Hall to get the discovery, and more importantly, work with Mr. Mazaku about what he wants to do in this situation?
Judge, the discovery that's outstanding, I mean, I don't know how long it'll take. I mean, it sounds like we've got it all. If I can get it, I don't need very long. Essentially, Your Honor, I'm just looking for anything that makes me tell my client, you need to do this.
Sure. And you didn't find Mr. Willis, I don't know what all in the 3 hours he said. We certainly heard some things here that if a jury heard, for example, the police being led to Mr. Massacru's home based on the ping from the laptop, and then these text messages. Now, that's what the prosecutor said, but she had a basis for saying it. So maybe, for example, the phone dump would help.
That potentially, yes, Your Honor.
Okay. All right, and I'm not trying to strong arm anyone. If Mr. Massacre wants to go to trial, it'd be a fascinating trial for the state to work through. If it
Will be
star
entertaining.
witness is when. You don't need to take this. So, this case has rattled around for a while. Mr. Massacre is always on time. In fact, he's always early. I don't want it hanging over his head either if it's resolvable short of trial. So if we get it on a final plea calendar in about a month, I'm going to assume that's enough time. And in fact, I'm going to direct you, Mr. Henriksen, to let us know more than a day in advance if it's not enough time. It's not your fault if you don't get what you're entitled to, but if you come in the day of to say, hey, by the way, I'm missing all these things and I've known for a minute that I didn't have them, then we need to structure it a different way going forward. So let Ms. Nelson know, but she'll figure out a date that is about a month out. And I guess also, if you know, we need to get on the record that it's not working out, if it's not going to work out, so that later on, someone couldn't say it was going to work out.
That's more than fair. And I'll let the court know, I have gone over everything that I do have with my client. I've gone over the offer, gone over the consequences of the trial. Obviously,
Sure.
On paper, this is a very fair, to say the least, deal.
Okay.
Factually, I just need to be able to tell him.
I got it. You need to do your work, and Mr. Masker needs to make an informed decision. Hopefully, hearing today's plea colloquy will help shape what he decides to do. Mr. Masker, do you have any questions of me before we break for the day? Okay, I appreciate you being here. Ms. Hall, if you run into any problems getting Mr. Henriksen what he's entitled to, please let Ms. Nelson know before the next final plea calendar.
Thank you.
Last thing, I got the indictment right here. Do you authorize me to sign it on your behalf and your client's behalf, Ms. Patel?
Yes, Your Honor.
Okay, sorry. Great, I will do that. I appreciate everyone's work on this star-crossed case. I've asked this before, do I at least have the pleasure of having Ms. Wen's case, or is that in another division? You guys are invited.
Your Honor, that's my only matter of having excuse.
You all may, thank you.
Thank you, sir.
Anything more, Ms. Crawford?
Judge, that's all for me.
Great, thank you. Thank you, Ms. Nelson.